May I say that two
Yes.
items may come up on 26th matter, admission matter.
Which matter?
Admission
Item?
matter may come up on 26th line.
There is a senior bench. There is a senior bench, sir. You have to mention it there.
May I please,
Yes?
Your Lordship, item number 18, Lordship,
1-8.
1-8,
Huh?
1-8, Lordship. This matter may come after 2 weeks, Lordship. I'm led by learned senior counsel M. Bora, Lordship. He has some personal difficulty and I have taken consent from the other side also.
Okay. At the request of the learned counsel for the petition, list this matter again after?
2 weeks, Lordship.
No, we'll have to fix a date. We'll go for
After Bihu, if possible,
22nd of April.
Lordship. And there is an interim order operating,
The
Lordship.
interim order passed earlier continues.
Deeply obliged.
Yes, madam?
I beg to mention item number 19.
Huh?
I humbly seek adjournment for the matter as the lead counsel is unwell. And for the petitioner,
At the request of the learned counsel for the petitioner, list this matter again on 24th of April.
May I please, Your Lordship?
Yes?
Lordship, with regard to supplementary list, item number 51,
Hmm?
we have filed an objection, Lordship. It may be called for.
Yeah, I want to mention here item number 36 of today's list, Lordship. I will be allowed to inspect the record.
Okay.
Lordship.
May it please, Your Lordship.
Yes.
Lordship, I'll beg to mention daily list item number 39 and 40. CD has not been received. So matter may be adjourned for it. And interim is yes, Lordship. Interim may continue.
Yes, when do you want it, PP?
Petitioners are perhaps on interim. Let
Are you
them-
an interim?
Yes, Lordship.
After vacation?
27th of April?
Lordship. Obliged.
Learned APP has submitted that the case diaries are awaited, full stop. The petitioners are on interim protection. List again on 27th of April, 2026, allowing the APP to bring the case record, case diary. Interim order passed earlier continues. Yes,
Much obliged, Lordship.
Lordship, I beg to mention item number 44. It may be
44.
passable for the day. My senior had some personal difficulties, Your Lordship.
At the request of the learned counsel for the petitioner, list this matter again on, when do you want it?
After 2 weeks,
10th of April.
obliged.
May please, Lordship. My lord, in item number 2, we had filed an additional affidavit. That has not had been, so not on record. That will be called for, my lord.
Give it. Give the slip.
May I please?
Yes,
With the consent of the Honorable Lordship, I beg to mention item number 20, Lordship.
20. Yes,
Lordship, may I fix after vacation, Lordship? If possible, Lordship, 11 May, Lordship.
at the request of the learned counsel for the petition, list this matter again on
11 May.
11th of May. 11th of May.
May I
Okay.
please, sir?
Hmm.
May I please, Lordship? I beg to mention item number 23, my lord.
Huh?
23, as per
CD is awaited. So when do you want it?
Lordship, 10th of April?
At the request of the learned counsel for the petitioner and on the submission of the learned APP that the CD is awaited, list the matter again on 10th of April. Yes,
May I please, Your Lord? Item 1, this is related to item 23, my lord. It
Ah.
did not come.
in item 1 you take down. It is submitted that this matter arises out of the same FIR as in BA number 442 of 2026.
Yes,
Full stop. List this matter along with BA number 442 of 2026 on 10th of April 2026.
Deeply obliged.
May I please?
Yes.
Lordship, I beg to mention item number 14 of daily list. Lordship.
41,
14, 1-4, Lordship.
14, yes.
Lordship, matter may be taken after due vacation, Lordship.
At the request of the learned counsel for the petitioner, list this matter again on 27th of April,
From 24.
24th of April, 24th of April. Okay.
May it please, Lordship.
Mhm.
Lordship, I seek your permission to go to the records of item number 30, my lords.
Mm.
Thank
Okay.
you, Lordship, deep privilege.
May I please, Your Lordship? I beg to mention item number 22.
22, yes.
Kindly adjourn the matter for the day.
At the request of the learned counsel for the petitioner, list this matter again on after Bihu, 20 April 2026.
Okay.
Yes,
Please, Lordship. Lordship, item is item number 6. I beg to mention, Lordship, item number 30, 31, 32, and 33, same allegation.
30,
31, 32, and 33. So, Lordship, kindly take the matter. NCD is not received, I think.
31, 32, 33 already tagged.
Received, Lordship.
My item number is 6, Lordship.
You want 6 to be taken up with?
Yes, along with 31, 32, and 33. Same allegation, same.
CD is received?
Yes, ma'am.
Yes, we'll take it up along with 30, 31 and 32.
No.
30, 30, 31, 32, 33.
32, 33.
Okay.
May I
Yes.
please, the Lordship? Lordship, I beg to mention item number 38, Lordship.
38.
I'm
Yes.
appearing on behalf of R. Bora, Lordship. He
Huh?
has some personal difficulties today, Lordship.
Then why by order?
No, Lordship, he had some personal difficulties. Probably he went home yesterday.
CD is
Lordship.
received.
Yes, sir.
Lordship, can it be taken on?
Although the
26th?
case diary has been received, comma, at the request of the learned counsel for the petitioner, list the matter again on
26th.
26th,
Lordship.
26th of April, 26th of March,
Lordship.
2026. Yes,
Like, I beg to mention for listing your honor, DH.
senior bench is there, sir.
Lordship, I beg to mention item number 42.
42, yes.
We were required to take steps. We need some more time to effectively take steps, Your Lord. Can it be listed in the first week of April?
When?
First week of April.
At the request of the learned counsel for the petitioner, list this matter again on the 1st of April, allowing him to take steps.
I'm deeply. Abeyance order,
Huh?
the order of abeyance may be extended.
The interim order continues.
Obliged.
My lord, if I may allow to check the record of item number 32.
Hmm.
Obliged. You should be here, item 2.
Last time I was directed to file an affidavit,
Hmm.
well, not direct affidavit, to prove my residential address. I've already filed, but that has been not been recorded, so I've mentioned,
Residential address.
yes. Because of, yes, because I am a resident of Odisha. So both in both the case, in both the bail application, it was rejected on the ground that I have no permanent address at Assam. To this ground.
So have you given any address now in the
Yes,
state of
I've-
Assam?
My,
You have filed the affidavit.
I filed an affidavit.
We'll
with
take it
other-
up after some time.
Yes.
Let the affidavit come.
You also check also, yeah.
Let the record come.
Let the record come.
Item 3.
Yes, sir.
Lord, this is the second application, my lord. My lord, this is in solicited case. And my lord, in this case, there is real contradiction between the prosecution story and the.
This is a bail, is it not?
It's a
It is
solicited
POCSO.
matter, solicited matter,
solicited
NDPS,
POCSO.
NDPS, Lordship.
NDPS, okay.
Out of 7 witnesses, 2 witnesses already been examined.
Out of 7, 2 have been examined. Okay.
My lord, in this,
Where is the earlier order?
Lordship at page 48.
48. Why did we reject it? No, page 48 is not the earlier.
Lordship 21, 2026, there's an order from this honorable court.
Which page is it, sir? Yes. We'll call for the TCR. We will call for the TCR now. This is a bail application in connection with. You will find it at page 1, Special case number so and so, so and so. Call for the scan copy of the trial court records. List again on 6th of April.
Lordship. Along with the depositions of the prosecution witnesses.
Along with the deposition of the witnesses already examined.
Lordship.
Item 4.
Why a bail application for a minor?
That is what, Lordship.
Huh?
Because he has
Lordship is a minor lordship. I have.
made some offensive comments on social media.
At page number 16, lordship.
Can a minor be held?
Minor is entitled to get the.
Why do you say he's minor from where?
Lordship, at page 29, lordship, I have annexed a certificate, lordship, full certificate. It is countersigned by the,
You did not place this before the trial court.
lordship, it is produced before the police, lordship. Police not accepted this.
You did not put it before the trial court.
Let him appear before the trial court.
You have to put it before the trial court.
Yes, sir.
Lordship.
Hmm?
But before police, lordship is submitted, lordship.
That is your statement. Police will say not submitted. Can we decide that? No. Trial court can ask for a proper verification, huh?
Otherwise.
Balloon also proper. তেওঁ এই বিদ্যালয়ৰ চতুৰ্থ শ্ৰেণীত পঢ়ি কিমান শ্ৰেণীত? চতুৰ্থ?
Class 4th, lordship.
Class 4.
Lordship.
And in the FIR, he has been
2018.
In the year, lordship, seizure leave, lordship, they have mentioned as 18, lordship, and in the forwarding report, lordship, they have mentioned as 19, lordship.
19, Lordship.
Seizure list is, lordship, at page 27, lordship.
Two 2008 born. 2008 May. What is the incident about?
Lordship, that was occurred on
April.
7/3/2026.
April. No, March.
Yes, March.
Then he's not 18.
Not at below 18, lordship, but
Then he's not 18.
17 years, 9 months.
But again, that school certificate has to be verified.
Yes, let him appear before the trial court
And
first,
if it was there in the Caesar list,
Lordship.
where is the Caesar list?
Seizure list perhaps not annexed, Lordship.
Yes, annexed,
It's
annexed.
26, Lordship.
26, 27.
What has been seized? Redmi mobile.
Yes, Lordship. Only
What do you
mobile.
do? You want to go to the trial court and produce this so that they can have a verification or what?
Lordship, direction may be issued, lordship.
Huh?
I will produce this.
Your name, sir?
B.U. Laskar. B.U. Laskar.
Heard Mr. B.U. Laskar, learned counsel appearing for the petitioner. Also heard the learned APP. The learned counsel for the petitioner has submitted that as per the school certificate of the petitioner, comma, on the date of the alleged offense, the petitioner was a minor, full stop. A photocopy of the certificate issued by the school authorities is annexed to the petition, full stop. After some deliberation, the learned counsel for the petitioner has sought for the leave to approach the learned trial court along with the certificate. Praying for appropriate relief. Full stop. It appears from the documents annexed to the bail petition that the aforesaid certificate had not been placed before the learned remand court. Full stop. Accordingly, this petition is closed, giving the liberty to the petitioner to approach the jurisdictional court along with the certificate issued by the school to pray for appropriate relief, since the petitioner appears to be a minor on the date of commission of the offense. Bail application closed with the liberty as aforesaid. You give the document there, you are out of the case. Why should you pray for a bail?
Lordship.
They have filed an additional affidavit.
Yes, yes.
I've annexed that documents, the Aadhaar card, page 15, 59. Form this is address. Same address is given in the
Where is that order rejecting the bill?
Yes. First order is page 45. Relevant part page 46. In this, it appears there is no permanent address of the accused name. It is evident accused is resident in another state, Odisha. Moreover, no consent material in place on record.
Page 45.
46, 46, Lord.
46.
Page 46.
46.
Now they are saying there is no permanent address
The,
within the jurisdiction of this court.
yes, that is what they,
This is what.
And now also you have not given any
yes, to that regard.
any
Lord.
place that yes, I can stay here, or this is the man I know and I will stay here.
Thing is that if I had it been in from Assam, then the question would have been not arisen. Since I am arrested in Odisha, Assam from coming from Odisha, how can it be how is it possible that I
You took a risk when you were carrying all those
No.
substances. Then,
this is not this is impersonating as a CID inspector.
you came from there to impersonate here. You took a risk. No one will know me, so
Mhm.
I'll be able to run away.
My lord, if you also go through that, the police have also verified the address also. Because from the checklist, it is page 53 checklist. The address which is given in my Aadhaar is similar to the address which the police has verified in checklist, page 53. Same address,
Where do you find it?
page 53.
Address so and so.
Yes. This is checklist for.
And what was your ground? What was your ground for bail?
Ground for bail? Charge sheeted case, my lord.
Scan copy will be required.
Sheeted case. Okay, we'll have the case diary, the scan copy. We'll see what is there. We'll have it soon on on April 7th.
My lord.
7th of April.
Only the thing, my lord, is that scan copy is there, my lord, that he used. 51 pages there.
What is 51?
Page 51, my lord. That's order passed by the Lioness Session Court. I have considered the rival submission. There was no quarrel to the fact that the accused.
It has been charge sheeted. To what extent now it has progressed?
The investigation, the evidence stage.
That is what we wanted. That is why the TCR, sir.
Yes.
That is why the TCR.
Yeah.
We'll have the TCR, and there are orders from this court where bail had been granted to persons who were from outside the state. Have you got any orders with you?
What fact?
Sure, Sona.
Exactly. This is the other one, first one from Himachal Pradesh, Shimla, relevant para 12. আর একটা কপি আপনাকে বলে দিতেন এটা একটা গুয়াহাটি হাইকোর্ট ওয়েবসাইট তাই
This is a case where it was a case for acquittal for the co-accused. We are not on that.
The other case is for para 12. Para 12, if you also go through it is submitted at a petitioner,
Just a minute.
is a para 12, page 9.
Allegation is a fraud. He would vanish without a trace. Huh?
I am not
In the absence of authentic documents as regard to the party of the.
No, the thing is
There
he
are
has
many
given the
charges
Aadhaar.
across
He has
the-
given the Aadhaar card.
Yes.
When I asked for an order, they have not been able to place the proper one.
Yes.
But if you have a look at, I don't know, Pamidi Anand was one case. We'll have this at 2. At 2, you try to bring out that order where this court has granted bail to persons who are not residents of the state. In the other case, we are finding that she was arrested
He was arrested.
because she did not appear in the trial. The co-accused got this thing, acquittal.
But the Himachal Pradesh is clearly
Are
written.
we,
Himachal Pradesh which has.
Himachal Pradesh again depended on its own judgment. That is what we are asking you for. Are we delaying the matter in any manner? Why don't you have it at 2? Pamidi Anand বুলি মই তাকে কৈ থাকো তাতে কন্ডিশন কেইটামান আছে Pamidi Anand 2025 or হয় credit petition sorry bail application PAMIDI Pamidi
Item 5.
we'll have it at 2. We'll try to see if we can give it. Yes sir.
Wait, please, Lord.
Yes yes.
It's a regular bail, my lord.
Ha.
Also, may I have a look at page 14, my lord, 1-4, my lord. Lordship found there, my lord. I am appearing on behalf of that Elina Khatun, my lord.
Elina, okay.
Next page, my lord, 15, my lord. Brief history of the case. The brief facts of the case are that on so and so, the complainant Gokul Das, resident of so and so, my lord, lodged an FIR in this police station stating that on the same day, at about 2:30 am, 4 unknown person broke open the shutter of his shop, so and so, located at Lokra Chareli, and committed theft approximately 2,000 kgs of brass dishes and bowls from the shop. The entire incident was captured in the CCTV camera installed at the shop premises, which clearly recorded the occurrence. Now, your lordship will turn to below, my lord, grounds of arrest number 2, my lord. During the course of interrogation, the previously arrested prime minister.
The husband received it and sold it somewhere. The wife is in for nothing.
My lord, what happened, my lord? I came to know, my lord, the husband purchased, my lord, to the mobile phone of her wife, my lord, ATM, my lord. And my lord, I'm praying on her behalf as because, my lord, she had a minor child, my lord, that I have annexed at page 20, my lord, annex of home, my lord. 4 years, my lord.
Yes, both husband and wife, 4 years, woman.
Lordship, otherwise.
Husband inside, let him be inside for some time.
Yes, no.
Huh? Heard Mr. N.J. Dr. Learned Counsel appearing for the petitioner, also heard the Learned APP. This is a bail application, praying for regular bail in connection with, you'll find it at page number 1, the second, this thing, huh? The petitioner was arrested on 17/3/2026. Stop. The allegations as leveled in the FIR and as revealed from the, this is the forwarding. The forwarding report appears that the wife, the husband of the applicant had received some stolen items and made a payment through her Paytm, and therefore the petitioner has been taken into custody along with her husband and another person, full stop. The learned counsel for the petitioner has submitted that the petitioner has a 4-year-old minor child who needs care and attention, full stop. Call for the case diary, list again on 20 April 2026. It is this court, on going through the contents of the forwarding report, is of the opinion that the petitioner at this stage can be allowed the privilege of an interim bail, since she also has a 4-year-old minor son and the husband of the petitioner has also been arrested along with her, and there is no allegation that the petitioner had led to the recovery of any stolen items, full stop. In view of the above, the petitioner shall be released on furnishing a bond of rupees 15,000 with 2 sureties of the like amount, subject to the satisfaction of the Judicial Magistrate First Class Kamrup Metro Guwahati, Assam. The learned magistrate shall be at liberty to impose such other conditions as may be necessary to ensure that the petitioner does not that the petitioner participates in the investigation. Full stop. Further continuance of this bail would be considered on receipt of the case diary. list as noted above.
Item 6.
এইটো লগত আহিব 31, 32, 33 লগত আহিব। এটা সেইকেইটাৰ লগত মাতিব কেছ ডায়েৰীত সেইবোৰ লগত।
7. May please, your lordship.
Yes.
Here, my lord, NDPS, my lord, intermediate quantity, my lord. Intermediate quantity, my lord. 4 kg 649 grams, my lord, of ganja. Has been
Where is the FIR?
allegedly recovered, my lord. That is at page 7. Remember, that is important. At page
Page 9, Lordship.
page 9.
We'll call for the case diary.
Lordship. Thought that maybe pick from bottom, my lord. I'll put
This is a bail application under section 483 in connection with page 1. I have marked in pencil. So and so call for the case diary list again on
Lordship, 2nd of April.
2nd of April.
I'll oblige, my lord.
Supplementary report list, item 47. Please, your lordship. Lordship, translated copy of the FIR, page number 20, lordship.
Yes, kindly tell us. Madam,
Lordship,
you were
yes.
required to find out what was the meet.
Lordship, here, Lordship, charge sheet has been filed.
So,
Yeah, allow to, we'll.
but you are inside. Once the charge sheet has been filed, we'll call for.
Kindly allow your regular bill, your lordship. We'll.
Once the charge sheet is filed, should I allow it
No,
here?
Lordship, let him appear before the trial court, Lordship. In the trial court.
Two options. One, will call for the copy of the charge sheet, the TCR,
Yes.
to see in the charge sheet as to what is the kind of meat or whether there is any indication that it is something prohibited. Or you can withdraw, take a chance there, come back. Your choice.
Call for that.
The learned APP has submitted that the case, that a charge sheet has been submitted by charge sheet number
08 oblique 2026 dated 2802/2026.
You have taken the number, charge sheet number? You have to take. Dated
2802/2026.
28 February 2026, full stop. Call for a copy of the, scan copy of the TCR with, from
CJM Kamrup Metro.
from CJM Kamrup Metro, list again on 6th of April,
Lordship.
Kindly 28 April.
28th, sorry, it's a close day.
6th April.
Or you can have it 30.
6th April.
6th April, list on the 6th of April. You also try to have your certified copies of whatever you can to show.
Item 8.
Please, your lordship.
In the FIR is page my lord 11. It's a POXO matter, my lord, notice maybe
Just a minute.
12 page the my lord operating department.
CDA notice. Is it about 16 years victim? Lordship?
16 years.
This is a petition seeking the privilege of pre-arrest bail in connection with page number 2, Full stop. Issue notice to the respondent number 2 as per the prevalent notification. Call for the case diary. List again on
Lordship, on 9th.
9th of April,
8.
8th of April,
97.
2026.
Only applies your lordship.
Yes.
Item 9.
Should kindly have a look to page 14 is the FIR. I am the owner of the vehicle, lordship. 14. Some category transporting by one Salwar Hussain, he was the driver. And that vehicle, lordship, I have already given on lease prior to the date of incident. Date of incident was 21 and I have given the lease on 20. I have annexed the.
One day before.
One day before.
To whom?
page 19 is the FIR. Sorry. Page 21 is the agreement
Huh?
between the parties regarding lease.
You are who?
I am Lordship Puluk Devonath. This was made on 20th of January and handed over on that very day. That is Lordship page 22 in the fourth paragraph.
Yes, madam, we'll allow the interim, let him appear, give the agreement, pick up the other person, we'll see.
Lordship.
Huh? Heard Mr. M. Khan, learned counsel appearing for the petitioner, also heard the learned APP. This is a petition praying for the grant of a pre-arrest bail in connection with page 1. Huh? So and so the learned counsel for the petitioner has submitted that the petitioner is the registered owner of the vehicle involved in the incident, and he had given the vehicle on lease to another person prior to the date of the incident. Full stop. He accordingly prays that the petitioner may be granted the privilege of a pre-arrest bail. Call for the case diary. List again on
Lordship, on 23rd of April.
23rd of April. In the meantime, it is provided that the petitioner shall appear before the investigating officer of Bilasipara PS case number 24 of 2026 on or before the 31st of March 2026, full stop. In the event of the arrest of the petitioner, prior to the next date of listing, the petitioner shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating authority. Yes, madam. you are saying
Lordship, actually, the deed of lease that was executed on the date of 20th day of January 2026.
Hmm.
On the same date, Lordship, the occurrence took place.
No. He will appear before the this thing.
Lordship.
Ayog.
Sure.
He has said offense is of 21st and he gave the lease on 20th.
Yes.
That is what I have recorded. If it is wrong, point it out on the next date.
Lordship.
We shall see what is to be done.
Lordship.
Is it not?
Yes.
Let him produce that agreement. Let the CDB
Date to get it.
reflect that.
22 or 23 আপনি যেটা বলেন।
Yes, sir.
Page 11 is the FIR. Allegation seems to be serious, but not against me. Well, I am accused number 2, Johor.
Just a minute. Saiful, I'm 30 years old, landowner, so and so illegally confined animal. The above minor kept in a
The main accused has already been arrested, the Soiful Islam. And
Then FIR is also given by Soiful Islam.
no, the
Huh?
no.
Apunar Bisakhi?
Yes.
Sofikul.
Sofikul.
Your English translation says Saiful. That is what I was thinking.
Yes.
The person who is the main accused is giving an FIR and getting himself arrested.
Absolutely.
We'll have to
But
send.
only the land only. And
Because he is the
whatever-
owner of the premises, Lordship.
Huh.
so whatever materials are being seized from the accused number 1.
Let us call
Is-
for the case.
But without
Page 19, kindly see.
without notice to
And the rejection order, there is no, to my understanding, this is not a rejection order.
where
Page 15. Simply it is rejected. Page 15. Last para. After perusal of the case diary, consider materials available in the case diary. I don't need to grant benefit of bail to the accused, the first Soiful. At this end, I am not inclined to grant benefit of PS bail to the accused. Nothing more.
after perusal of the case diary,
Why it was recorded, whether the sanction
after
or
perusal of the case diary, is it necessary that the case diary should be reflected there? No.
This serious allegation is trafficking of a person.
The
The
accused
allegation
person
without-
prima facie made a case.
But
with some-
madam,
some
tell us
kind of-
one thing.
Yes, Lordship.
The informant of the victim here,
Yes.
the informant here,
Lordship.
There's no
is
allegation
someone
from
who says that I know that this thing is happening
Yes.
there.
Lordship.
would
Let
notice
us
to them help.
CD will reveal everything, Lordship.
I have annexed the forwarding report of the main accused also. It does not say I am involved.
Because
Without
some unethical
being a
Something has
POCTO,
to be reflected in the
activities
forwarding
going
report.
on within the
I have-
premises of the
Because
petitioner.
61 is attracted.
These
Huh?
are somehow
Have to
involved,
say
Lordship.
that I have some link with the first accused. the
CD
main
will
accused.
reveal everything, Lordship. At this stage,
You know,
CD
there-
Lordship. Can anticipate your.
where is
Count of
your
errors, the
ground?
Page 23. And page 24, the para 6, the necessity of the custodial interrogation. Whether my involvement is there,
This
whether
is
I
your
have-
forwarding.
No, the accused number 1.
Where is your forwarding?
He's the anticipatory
It's
bill.
an anticipatory bill.
Anticipatory bill.
Lordship.
Oh, this is AB.
Yes, Lordship, maybe.
As per the FIR, they say that there is a conspiracy, but the forwarding report does not say so. That I have taken part in the conspiracy. Some person is running a school without any permission. That is not a crime.
Lordship, kindly go through the necessity for custodial interrogation, kindly page 24, the last paragraph,
24.
page 24. Because some kind of digital recovery of forensic examination of digital devices.
So that will all be from the person who is arrested.
Lordship.
Is it from the person who owns the land?
Lordship, identification of the other victims as
Yes,
well
I
as
will
the
appeal and-
co-accused, that is also required, Lordship.
No, that, tell me one thing, the school is running there.
Yes, within the
What is the
premises of the.
necessity of him being taken into custody because he has allowed a school to run there.
Yes, Lordship.
How?
But some illegal activities is going on within the premises of the petitioner, Lordship.
That will be stretching it too far.
That too in case of minor children, Lordship.
Mhm.
That is something serious.
Then
Lordship.
the owners of every rented
Every
premises
student-
would be at risk all the time.
No, if such
So it will be-
illegal activities are
It will
going
be
on,
a
Lordship,
very,
that
very dangerous thing to
have
say.
to be looked into, Lordship, otherwise.
Whatever material has been seized by the police. The two mobile has been seized from the main accused.
What is his involvement? That is yet to be, Lordship, revealed. The CD will reveal everything. And
Heard
anticipatory.
Mr.
I
S.
will appeal before
Bhattakul
the
on
IO, madam. Whatever case I have the knowledge, madam, I
Heard
have-
Mr. S. Bhattakul, learned counsel appearing for the petitioner, also heard the learned Miss S. H. Bora, learned APP, full stop. The learned counsel for the petitioner has submitted that oh no, sorry, before that you read, this is a petition praying for the privilege of pre-arrest bail in connection with Lahorighat PS case number 246 of 2025 under section so and so, that you will find it page 1, continue to page 2. Okay? The learned counsel for the petitioner has submitted that the petitioner is the owner of the land upon which a certain madrasa was functioning, and the teacher of the madrasa has been alleged to be involved in making pornographic videos of the minor children of the madrasa,
allegation is there.
and has been arrested
Yes.
on
On 1912.
19/12/2025, full stop. The learned counsel for the petitioner has submitted that the petitioner is the owner of the land on
Land.
which the madrasa is established, and he is not involved in any manner with the functioning or running of the madrasa institution, full stop. He has submitted that the petitioner is ready to cooperate with the police in the investigation against the persons who are suspected to be involved in the offences. Full stop. He has also submitted that although he has not been arrested for the last almost 3 months, the police are now looking out to arrest him. Full stop. Accordingly, he prays for the grant of privilege of pre-arrest bail. The learned APP has submitted that the offences are heinous, involving minor children, and therefore the grant of the pre-arrest bail would not be conducive to investigation at this stage. She has also referred to the orders passed by the learned jurisdictional court rejecting the prayer for pre-arrest bail of the petitioner, full stop. Having gone through the forwarding report of the accused who had been arrested on 19/12/2025, and also having regard to the submission that the petitioner is the owner of the land on which the madrasa is functioning, this court is of the opinion that the petitioner should appear before the investigating officer of the case to participate in the investigation, full stop. Accordingly, the petitioner shall appear before the IO of the case on or before 31st of March 2026, full stop. In the event of the arrest of the petitioner, he shall be released on bail on furnishing a bond of rupees 20,000 with 2 sureties of the like amount subject to the satisfaction of the investigating authority, full stop. It is seen from the FIR that the informant in the present case is, who is he?
Safiqul Islam.
No, who is he?
He's a local person of the locality.
He is a local person who is not connected with any of the alleged minors. And therefore, it is not found that he would be in a position to defend the interest of either the victims or of the victims. Don't say either. He would not be in a position to defend the interests of the victims in the manner, full stop. Accordingly, call for the CD on
Lordship 2804,
28th of April 2026, full stop. Notice to the informant would be considered after receipt of the CD.
May it please your lordship. Page 10 is the FIR, your lordship. Here, my lord, 11 cattle were recovered, my lord. I am the owner of the vehicle, my lord. My lord, it is alleged that, it is suspected that those cattle were stolen cattle. But my lord, I am the owner of the vehicle, my lord. And my vehicle was taken by one Faizul Islam to bring tea leaf from my lord Gauhati. Then he took the vehicle to my lord Dibrugarh, Borborua, loaded cattle, my lord. Now, my lord, my vehicle is on hire purchase, my lord. I'm nowhere connected, my lord.
432026. Yes, madam. What was-
11 numbers of cows has been
But is it suspected?
transported without any valid documents, Lordship.
No, he's the owner of the vehicle.
Lordship.
Does he need custodial interrogation
I
at
leave
this
it to you,
stage?
Lordship.
Let him appear, let him make the statement. If required. Heard Mr. S.M. Abdullah, learned counsel appearing for the petitioner. Also heard Miss S.H. Bora, learned counsel, learned APP. Full stop. This is a petition praying for the grant of pre-arrest bail in connection with Borborua PS case number so and so, so and so. On going through the allegations leveled in the FIR, this court is of the opinion that the petitioner should appear before the investigating authority of the case to participate in the investigation. Full stop. Accordingly, the petitioner shall appear before the investigating officer on or before 31st of March 2026 to participate in the investigation. Full stop. Call for the case diary. List again on 24th of April.
Lordship.
2026. In the interim, it is provided that if the petitioner is taken into custody, he shall be released on bail on furnishing a bond of rupees 15,000 with 1 surety of the like amount to the satisfaction of the investigating officer. Continuance of the privilege will be considered after receipt of the CD. It will likhiboi sobote, huh? Continuance will be considered to likhiboi. Yes, madam.
Yes, may it please your lordship. Your lordship, I am a homemaker and I am presently staying at my paternal home.
Hmm.
due to a matrimonial dispute with my husband. And my daughter is also pursuing her studies with me at Dhupdhara, Your Lordship,
Hmm.
Goalpara.
Hmm.
But recently I have received a summon from the DRI, Your Lordship, custom alleging that poppy seeds along with 11,090 sticks of cigarette has been seized. And in this case, I was called uh, for APR, Your Lordship.
Hmm.
And the similar kind of summon has been also received my husband.
Hmm.
That is the space number 18.
Hmm.
Your Lordship, presently I am staying with my mother. I don't have any relation with my husband.
Hmm.
And this summon is received at the address of my husband. So from nowhere I am connected with this alleged offense, Your Lordship. So I am ready to cooperate, Your Lordship, but
From when are you staying separately?
Your Lordship, almost 1.5 years, Your Lordship.
That is not given anywhere.
It's para number 7, Your Lordship.
You only said that you remain separate.
Yes, Your Lordship, for 1.5 years, Your Lordship. And the alleged offense as 24/9/2025, Your Lordship. Recent.
24/9/2025.
Recent, Your Lordship. Page number 9.
Yes, sir.
Your Lordship, let the CD be called for because they have not annexed the FIR also. So
We understand that. Where is the FIR? She doesn't have a copy. She only has a copy of the notice.
That's
How can she? The moment she goes for an FIR,
Lordship, they can
the nomenclature of the petition changes. Is it
but
not?
at the same time, Your Lordship, let the CD be
We'll do that, but
next to
she
next
has,
week, Your Lordship.
we'll record her statement that she's staying separate from her husband for the last 1.5 years
Yes, Your Lordship.
and that she has a child. She will appear before you, have the documents collected. We are not protecting the husband as such. He is not before us. We'll make it clear that it is only because of the child and her statement that they are separated.
Your Lordship, not a child.
It's a daughter?
Daughter, she's
Yes.
studying college. Your
Yes.
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 Doesn't need the mother.
Child, Your Lordship.
Lordship. At the same
Let
time,
us
Your
not
Lordship,
object on that, huh?
let it be taken up on Monday. I'll get the instruction. Your Lordship.
Your Lordship, I am a woman. I have submitted before this honorable court. I am ready to cooperate in the investigation. Your
Because
Lordship, so far
I'm
in my
totally in the dark
knowledge,
here.
Your Lordship, so
But
far
I'm
in my
not sure
knowledge,
what
poppy
is the
seeds.
offense?
It is the offense is cigarette and poppy seeds.
Your Lordship,
Yes, Your Lordship.
9,000 kgs of
Cigarettes. 9,000 kgs.
9,000 kgs of
Where did you get it?
in their own in this application itself. Page 3. In the summons also.
Today is a Monday. Have it day after tomorrow. Can you have your instructions
I'll
day
not
after
be here
tomorrow?
on 25th and 26th. On
25th
Friday,
and
Your Lordship.
26th. 27th? Let him have his instructions only on the extent of why you are being summoned.
Yes.
If it is because of your husband, fine enough. Because he appears to be involved or your account has been used. Or if there is some direct involvement indicated,
Recently, I have gone through a judgment, Your Lordship, if Your Lordship permit, where stated that poppy seeds, Your Lordship, it's not a
contraband.
Yes, Your Lordship. Even in the
Opium, Your Lordship.
Where is opium?
opium, it's poppy seeds, please.
Poppy
Don't,
seeds.
no, there is two difference, Your Lordship.
Poppy seeds are used for opium.
No, Your Lordship.
The
The
opiate.
no.
That is what most of the people have in their house also. Afuguti is something we understand to be.
Yes, Your Lordship.
Is it
I was
not?
just talking with Mr. Dhar. In Bengali, there is a posto.
Ah.
So after
It's
having
delicious,
posto,
Lordship.
it's a very
Kids are
sleepy.
going-
It's a very sleepy. After getting
Kids
a
are
good-
going to the shop and saying,
Yes,
Maya khujise na. We'll be taking so many people in on that, na.
that's what Your Lordship.
We'll
Too
allow
much
it
of
for-
anything is bad.
Huh?
Too much of anything is bad, Your Lordship. Even poppy
It
seeds
says
also.
if you drink too much of water, it may intoxicate
Yes,
you.
Your Lordship. Even that can be toxic.
Huh?
If
That can be toxic.
Sugar, what do you call that? Sugar rush.
Yes, Your Lordship.
Sugar.
If you take too much of sugar at a time, even then you may faint
Yes.
because it spikes and then it falls. We'll allow the bill. We'll allow the pre-arrest on the condition that we'll reconsider it once the CD is available.
Obliged, Your Lordship.
Poppy seeds and cigarettes. A woman.
Lordship, Friday, Your Lordship. Just, at least get.
No,
let
by
me-
Friday she'll appear. She'll give you the statement, whatever you need. Investigation will proceed. We find involvement, you need further investigation by her custodial interrogation. We'll do it. We will do it. We'll cancel the bill. If we find an involvement.
Very well, Your Lordship.
If we find an involvement, we'll cancel it. We will not hesitate. Prima facie, opioids and cigarettes when she's separated from the husband, let
That's
her not be
easy.
taken into custody just because she needs to, you want her in custody. Let the need be there. If there's a need, we'll allow it. We'll reject the bill. Yes, heard Ms. So-and-so, as being a learned counsel appearing for the petitioner, also heard Mr. Bora, D. Bora, learned counsel appearing for the DRI, for the
For a D-
customs,
For the DRI. Your
for the
Lordship.
DRI, full stop.
Two, respond number two.
For the respondent number 2, the petitioner has received a summon dated 9/3/2026 requiring her to appear on 16/3/2026 before the concerned authority in connection with recovery of a seizure of 9,014 kgs of poppy seed and 11,900 sticks of cigarette of foreign origin, full stop. The learned counsel for the petitioner has submitted that the petitioner, no, the husband of the petitioner has also been summoned in the case to the best of the knowledge of the petitioner, full stop. She has submitted that she has been living separately, the petitioner has been living separately from her husband for more than 1.5 years as of today. And she also has a child who is undergoing education along with her after the separation from the husband. And when the petitioner is living with her own mother in Gwalpara, full stop. The Legal counsel for the petitioner has prayed for grant of an interim protection to allow her to appear before the investigating authorities and make her statements. Full stop. The Mr. D. Bora, learned counsel, has submitted that the recovery, the seizure in connection with which the petitioner has been called for is huge, and therefore she should not be granted the privilege of a pre-arrest bail, full stop. Going through the submissions and the documents annexed to the bail petition, this court is of the opinion that the presence of the petitioner before the investigating officer at this stage will help the investigation proceed in the right direction, full stop. Keeping in view that the petitioner has been living separately from her husband for the last 1.5 years, and also that she has an aging mother and a daughter, this court directs the petitioner to appear before the investigating officer when?
17th was the date. As per the summons.
16th is already gone. Give us another date.
Lordship, by
31st of March? On or before the 31st of March 2026 to make her statements and participate in the investigation. It is provided that in the event of the arrest of the petitioner, she shall be released on bail on providing a bond of rupees 20,000 with 2 sureties of the like amount to the satisfaction of the investigating authority. Full stop. It is made clear that this bail has been granted only on the submission that the petitioner has been staying separately from the husband and that she has got a school-going children and she is not in any way involved in the goods which have been seized by the Customs Department. Full stop. The continuance of the interim order will be reconsidered on receipt of the case diary. Full stop. Please the matter again on. Give us a date.
Lordship, April 6th or 7th?
7th of April.
Your lordship, I will be out of station, your lordship.
When do you want it? Tell
After
us.
Bihu vacation, your lordship.
20th of April, immediately after Bihu.
Yes.
20 April, 20 April,
Bless
20th of April 2026. Full stop.
Deeply honest.
My lord will peruse the order dated 19/9/25. There are the connected IA in this. There was a connected IA, my lord. I have the order, my lord. 19/9/25. There was a specific direction, my lord, to the petitioner to implead a private respondent, my lord. Specific order. He filed a review petition. I raised it initially. Court directed to implead. He filed a review petition and IA was dismissed, directing him to implead within 15 days. That is the order. I have just placed before your lordship.
So now
Now the
he
petitioner
has not impleted
don't think because
and he is not appearing.
he didn't appear and I don't find any IA, my lord.
Heard,
connected to it.
Mr. Ard, her learned counsel, a learned additional senior
No, my
government,
lord. Here I am for
learned standing counsel,
enforcement.
enforcement directorate. Full stop. This court by the order dated 21/7/2025 had directed the petitioner to file an amended cause title by impleading a certain respondent number
No,
2. By impleading a respondent number
yes,
2.
yes, my lord.
Full stop. It appears that such an amended cause title has not been filed till date. It is also noticed that at the initial stage on 18/6/2025, the objection of Mr. Dhar to the maintainability of this petition had been noted. None appeared for the petitioner on 3/12/2025 and on 25/2/2026. Full stop. It appears that the petitioner is not keen to pursue the cause. Full stop. Accordingly, this writ petition is closed for non-prosecution. Disposed.
For admission, item 15 to 17.
Yes, there was some instruction not to appear. Someone had made a prayer.
For the petition, item 15 is filed by the husband. This is a matrimonial dispute, my lord. Effectively, item 15 is.
You are
filed-
appearing for whom?
I am appearing for the wife.
And in item 15, who's appearing for the petitioner?
None seems to be appearing on the last.
Will proceed.
But item 16 is my criminal petition.
You want to pursue it?
I'll pursue it. No, there's nothing in the
Is
FIR.
the matrimonial relationship still existing?
No.
No.
But my lord, in item 15, what they say, first matter, 334. I had invoked the jurisdiction under the DV Act. They come before the High Court, while the DV proceedings are pending, they come to the High Court, they say that the marriage itself is void. Because the petitioner.
No. See, we'll take it down to very, very small area. Cases are there because the law needs to be settled. Cases are there because there is a grievance, and cases are there because you did something wrong, I'll not let you go. In short, 3 alphabets, EGO. Is it? So try and find out whether this requires an adjudication. If you really think this requires an adjudication and needs to be pursued, even in view of the fact that the world is moving so fast that a person doesn't have the time to look back to his own house at times, does it require to be pursued?
I'll take instruction.
We'll decide it. We are here to decide it. We'll adjudicate.
Well, only thing is that if item 15 is closed, then my DV proceeding continues because there is a state to the DV proceeding.
Would you require that to proceed? Would you really be keen to pursue it?
Because there is maintenance involved and there is a child involved. Because the DV
DV and child. Why the DV and child?
No,
maintenance. How is the DV related to the child?
No, under
and
the
if you are not staying with that man anymore.
Under the DV proceedings, I was given maintenance for myself and for the daughter, then minor daughter, now a major. Now, this DV proceeding has been stayed on the ground that the marriage itself was void.
Now, what do you say? Should we hear this on merits then? Why was it stayed?
My lord will kindly take para 12 of 334. That is his case.
334. Okay. Para 12.
para 12 at page 29, married, that since the marriage of the petitioner with the respondent number 2 was a nullity and void in view of the fact that the same was solemnized during the subsistence of the first marriage, the respondent cannot claim herself to be an aggrieved party having domestic relationship with the petitioner and can at best be termed as so and so, so and so. Now, his case seems to be that when he got married to the respondent number 2, at that time his earlier marriage was already subsisting. And therefore, me invoking the jurisdiction under the DV Act was not permissible because my marriage with him itself was void.
Oh, this is the doctor. List before a bench. Without me. He will be before a bench without me.
I'm good.
Item 21.
May I please, Your Lordship?
Yeah.
I'm appearing for opposite party number 2, Your Lordship. Your Lordship may kindly allow me for some time, Your Lordship, to see whether I have to file an affidavit, Your Lordship. Actually, I am the wife of legally, I am a legally married wife of
This is
the
the
petitioner.
POCTO case.
Yes, Your Lordship. And
And
now I am the legally married wife, Your Lordship.
you have married him.
Yes, Your Lordship. On 8/1/2024, Your Lordship, the marriage was solemnized, Your Lordship.
By that time, the victim was a major or a minor?
At that time, I was minor, Your Lordship. And as because my family was against me, Your Lordship, they have forced me to file the false case, Your Lordship, against the petitioner, Your Lordship.
There is a child also.
Yes, Your Lordship.
Any
On
fact is there?
31/7/2022.
You are appearing for the respondent number 2.
2, Your Lordship.
Charge sheeted case.
Yes, Your Lordship. The search sheet has been filed and Your Lordship.
You are appearing for? Yes, sir. You are the state. Now, she says married. She says child. She says she will file an affidavit. Should the proceedings go on? The proceedings in the trial court.
Your Lordship, it would be difficult for me, Your Lordship, to
Because if she appears,
use evidence against my.
if she appears, she will not give any evidence.
Yes, Your Lordship.
Hostile. Then you will have to cross with the child crying in the court. We will avoid that process for the time being. Heard. None appears for the petitioner on call. However, Mr. So-and-so and counsel appears for the as the APP and your name, madam,
Mamon Soikia Sundi, Your Lordship.
has appeared for the respondent number 2 on. You have received notice, na?
Your Lordship, yes, Your Lordship, I have received notice.
Have received on receipt of notice, full stop. The learned counsel appearing for the respondent number 2 has submitted that the respondent number 2 is. I said none appears. Don't want to appear.
I was in court number
Okay.
5.
Had Mr. So-and-so petitioner to. The learned counsel for the respondent number 2 has submitted that the respondent number 2 is now married to the petitioner and in fact she would face difficulties in appearing in the trial against the petitioner since she is also now blessed with a child. In view of the submissions made, the further proceedings in connection with special POCSO case number 74 of 2024 arising out of Ding police station number 184 of 2023 pending in the court of Special Judge Nagaon.
Nagaon, Your Lordship.
Special Judge Nagaon be kept in abeyance till the next date of listing. The respondent number, the learned counsel for the respondent number 2 has sought for an accommodation to file the affidavit on behalf of respondent number 2. Allowed, list the matter again on 24th of April 2026, by which time the respondent may file her affidavit.
File your admission.
Item 48, 8 to 59.
Yes, Lordship, item number 49 is the leading case, Lordship.
We'll take it up after some time. Let us finish up the criminal matters.
Very well, Lordship.
Bail hearing VA, item 24.
May I please, your Lordship. Lordship, this matter has been impacted, Lordships, because the petitioner has been acquitted by the London Trial Court, Lordship. More than 400 above he is in jail, Lordship. More than, Lordships, 410 days he was in custody, Lordship. But on last 17, Lordship was acquitted by the London Trial Court, Lordship.
The counsel for the petitioner has submitted that the petitioner has been acquitted by the learned trial court. Stop. Accordingly, this bail application does not need any further orders. Bail application stands closed. The learned APP, Mr. M.J. Burua appears and Ms. So-and-so appears as the amicus.
25.
Yes, sir.
Lordship, molestation, allegation of molestation against a tuition teacher, my lord. Allegation of molestation against a tuition teacher, my lord.
Tuition teacher?
Tuition teacher, 64-year-old boy, old man, my lord. FIR basically is a
The further custody of the petitioners, number 1 in BA number 844 and petition number 2 in BA number 559, namely Samsul Islam, son of so-and-so, and are directed to be released on bail on furnishing a bond of rupees 15,000 each, subject to the satisfaction of
the learned Chief Judicial Magistrate
Vishwanath. The learned CJM shall be at liberty to impose such other conditions which would to ensure the participation of the said petitioners in the charge-sheeted, no, still investigation. In the investigation of the case. Full stop. Considering the submission of the learned APP that the other two petitioners in these writ petitions, namely the petitioner number 2 in BA number so-and-so, that is Mohidul Islam, and petitioner number 1 in BA number so-and-so, were not involved in the examination process, but were involved, were not involved in the examination process, and that the FSL report of the mobile phones are yet awaited, the bail applications for those two petitioners are not being considered today and would be considered on receipt of the FSL report, which the learned APP submits, shall be available on 30 March 2026.
We'll try, madam. We'll try, madam.
Will be available on 30 March 2026. Full stop. Accordingly, list these matters again on 30th of March 2026. Examinees, they are out. And for the other,
we got an additional argument in other cases. Now, in other cases, if they say that they have signed notice through WhatsApp, we will ask for the FSL report of the.
No, my lord, notice through
in the other cases, WhatsApp.
No, notice through
My lord,
WhatsApp.
in most of the cases nowadays, 48, 47 notices are sent through WhatsApp in relatives without any FSL report. In those cases, they don't come up with this submission.
That you need the FSL report.
FSL report.
They need not, because you say that WhatsApp is not enough.
Not enough.
And you close the chapter there only.
There are instances, but these are.
Baki kita diba heard Mr. So-and-so appeared for the petitioner.
That in respect of
List. List along with BA number so-and-so. Awaiting the FSL report.
But the only thing,
Item 33 কোনটো আছিলে sir? Huh? The interim order passed for
Item number.
item number 33 কোন আছে?
BS 7
Only one person is there?
One person is there.
The interim order passed in item number 33. BS 750/2026 shall continue till the next date of listing. It is that his wife is expecting this.
Lordship, only thing that not involved in examination process, instead of that, can it be written when that
Were not candidates in
Candidates,
the
yeah.
examination karo. Was not involved in the examination process বুলি লিখিছো ক'বাত হেতু গুছাই পেলাই লিখি দিব were not candidates in the examination.
the CD may be returned back?
Huh?
CD
Updated CD may be called for
call for.
by the APP.
Because if they send back the case data within 7 days, it is not coming. Their submission is that FSL report. FSL report may be called for, but I have no.
If we allow them to retain if we order them to
My lord.
retain the CD, it becomes difficult because they will say that is why it is not proceeding.
My lord.
So we say he may call for it. He needs something updated, he will call for it. Is it not?
In that respect.
We will not ask him to do it or not to do it.
Absolutely.
Yeah. Yes, sir.
It is a lordship. But in this case, the petitioner is behind the bar for 265 days, my lord. And charge-
165 days.
65 days, my lord.
Okay.
Yes, and charge sheet has already been laid down in this case, my lord. The grounds on which the petitioner is before your lordship is the violation of the 36, my lord, 36 of BNSS, my lord,
Where is it?
which I have annexed, my lord, at annexer 5, page 47, my lord.
Huh?
Yes, and their lordship will find, my lord, record is also there, my lord.
Huh?
Only my petitioner's accused signature is there, and lordship will not find any signature of his family member or a witness, my lord. But the-
36.
Yes,
Why a family member?
it is required, my lord, under the law.
If the family member is not there, then some responsible person.
Yes, madam.
Huh?
And in that respect, my lord, I have also annexed two orders of this honorable court, my lord. And page 60, where lordship has clearly dealt with this aspect, my lord, how it is 36 is required.
No, but was it recovered? Any recovery made from your person?
Yes, lordship,
Yeah,
from this,
three
from the
persons
conscious
arrested,
persons of
madam.
the
Huh?
present.
3 persons were traveling in the car, my lord. I took a lift, my lord, as per the version of this petitioner, my lord.
Hmm. And which is the order you are saying that
Page 60, madam.
only 36 will be enough to?
Yes, lordship, page 60. And two orders I have annexed, my lord. And findings, lordship, starts from page 62, paragraph 6.
Yes, what do you say, madam?
Lordship, otherwise, I have found no such violation as regard to the procedural lapse as well as. lordship.
46, 47, 48, what?
That is duly complied with, lordship. I have flagged for-
I have annexed, my lord.
that
It is
is
complied.
I have an.
Only 36 is wrong.
Yes, lordship.
Then where is the where is the judgment?
I have 6.
Where is that order which says that if only 36 is wrong, then
Lordship, there is a
47,
judgment of
48 is
the
okay.
division bench, lordship, if otherwise, lordship, I'd like to refer to the order dated 6/8/2025 of our High Court, lordship, passed by the Honorable Justice Mr. M. Kalita.
Where? Show us.
Lordship, kindly, yes. Paragraph 8. Paragraph 14. Then yes. But in the inspection memo, lordship, the
Yes,
witness's signature is very much there, lordship.
Inspection memo.
Inspection memo, the witness's signature is very much there.
Inspection memo is for the purpose of, my lord, of obtaining the injuries on the body of the.
Otherwise, 47, 46, 48, all are complied with, lordship. And if any prejudice does not cause to the petitioner, so only procedural lapse does not amount to the warrant of granting of bail to the accused person. At the same time, lordship has to
Someone was
consider-
present during the time of your arrest.
No, my lord. 36 does not
Kindly
say so.
kindly go through the inspection
36
memo,
does not
lordship.
say so, my lord.
Kindly go through the inspection.
Where
memo.
is it?
Well, I have
flag
annexed,
mark,
my lord,
lordship. I have
inspection
flag
memo.
mark in the case. In the
Absolutely.
case
Yes,
report.
in petition also I have annexed, my lord. That lordship will.
47, my lord.
The last flag, Lordship.
Just a minute.
Has your Lordship got it? The last flag.
Yes, what is your prejudice?
My lord, it is, my humble submission is that, my lord, 36, my lord, relates to my fundamental right, my lord.
Huh?
Fundamental right, my lord. And it is a statutory provision which is strictly to be complied with, read with section 62 of the BNSS, my lord. And once there is a violation, my lord, that petitioner is entitled for, my lord, to be released on bail, my lord. And that has already been, my lord, discussed by your lordship. And I have, my lord, relying on another coordinate bench judgment, my lord. This is a very recent matter. That also, my lord, same aspect was there, 47, 48, but due to, my lord, the violation, my lord, may just place, my lord. Because they are, my lord, relying on the judgment of Honorable Apex Court in DK Vasu, paragraph 38, my lord.
If necessary information is received by the accused person as well as his relatives, while Lordship sections 47, 48 is duly complied with, what else is required, Lordship? Because there is nothing on record to show that he is prejudiced in any way whatsoever, Lordship. If it is not, then only on the procedural
Prejudice
left can he
come,
be.
my lord, when there is a violation, when it has been complied with fully by the state, my lord, then only, my lord, prejudice, my lord,
At the
my
same time,
understanding,
your
lordship.
Lordship also has to consider the gravity of the offense, Lordship. It's a commercial quantity that has been recovered from the conscious possession of the petitioner along with the co-accused, Lordship. 870.07 grams of suspected heroin has been recovered. And there is also judgment of this division bench of this honorable court, Lordship. Your Lordship's order is also there.
Lordship judgment, order is very clear at page 60.
And my order is very clear to
Yes,
the
very
extent that we
Yes.
did not consider when 48 has been duly complied with, number one. Number two, whether persons were present at the time of your arrest, what has been held in this Parvina Khatun Bibi.
Yes. Then,
When-
my lord, subsequently, my lord, the
Ah.
same bench, my lord, I got order, bail application 3650/2025. If lordship requires, I can provide a copy, my lord.
Get us a copy, we'll see. But otherwise, only 36 when everything else is okay.
Yes, Doctor.
These are the, my lord, another order may just placed before a lordship. That is also, my lord, very recently passed. 13/3, my lord.
Because no prejudice has caused to the petitioner, Lordship.
We can have a look at the order.
Lordship.
Yes. Copy.
Lordship has got it, my lord. Number two, duty. Okay, please. There are number of orders, my lord, in this,
Huh?
in respect to these aspect, my lord. But it has been held, my lord, that it has to be specifically complied with. Because any arrest made in violation of the section 62, my lord, is to be an illegal arrest.
The other provisions mandatory provisions are not complied with, Lordship.
There is no such wording, my lord, in that aspect. my lord.
Your Lordship's order is very clear to that extent, Lordship.
We had just noticed that you need not be answering each other. Two things happen. Our attention goes there.
Yes.
Sorry, Lord.
After some time, we'll take this up after some time.
Lordship.
But all of you should go for it. You get me that other order.
Yes, ma'am.
Obvious, Lordship.
Hmm? Nikhil.
May it be pleases you, Lordship. Your Lordship, I would like to take you annexure 1, page 16, where I am in as informant,
Hmm.
dated on 13/1/2026.
Hmm.
This information, your Lordship, FIR has lodged, your Lordship.
Ah.
Relevant, your Lordship, paragraph 3rd
onwards.
Hmm.
I'd like to read it, Your Lordship. That Sir, Madam, while they were in his classroom, he molested them and gradually doing every day, which is very much intolerable. That, Sir, the main thing is that he has been doing such molesting activities since long time, but no one fight
We have read
against
it.
him.
We have
Yes,
read
Your
it.
Lordship.
Yes.
So, Your Lordship, the trial has not yet started, Your Lordship. It may hamper, Your Lordship, the prime accused evidence, Your Lordship. So, Your Lordship, at this stage, Your Lordship, I would strongly objected this, Your Lordship.
Trial court records are here. I do so.
That's it, 69 days in custody, my lord.
Hmm?
69 days.
69.
69 days in custody. Offense punishable maximum is 5 years, my lord.
Hmm.
64-year old man, and lordship, they are in the custody of their parent, my lord. He's a school teacher, private, providing
Huh?
private teachers. So no question of hampering. Presumption of innocence is in my favor, my lord. So all these factors, my lord, I say, and most importantly, lordship, 35 notice has been not been complied with, lordship. So my entitlement to bail is there, my lord. And I've already suffered 69 days in custody, being a 64-year-old man.
Yes. Children had to record videos also because of your extremities, huh?
There may be, my lord, that
Hmm?
I don't know about the case record law. My submission is with regard to a length of detention, violation of the provision of section 35, my lord.
Which provision?
Violation of 35, lordship. The judgment
Yes,
that
what
we
do you
have
say on the 35 provision, madam?
There's a coordinate by judgment we have provided, lordship. And 69 days, my lord. Custody, if I've done something, my lord, I will face the music in the trial, my lord. It's not that I'm fleeing from justice, my lord. And maximum punishment, lordship, is 3 to 5 years, my lord. Maximum punishment that is that. In paragraph 3 of the, paragraph 6 of, 8 of the judgment, my lord, page 3, if your lordship takes up, my lord.
Petitioners think that that was a... Anyway, nothing is happening before the next date.
My lord, I am obliged.
Huh?
Can it be on 29 or 30 any day? Item number 54.
54, make it 29. Have you taken that the dictation, madam? Item 29? Item 54? You have taken that order? Make it 29th instead of 30. 29 of April.
43.
Mr. Burua, item 54, he has preponed it by 1 day.
May I please, Your Lordship?
Yes, madam.
Lordship, it's a very huge file, Your Lordship.
So,
It pertains to a DV matters.
no, this is in orders today.
Yes, Your Lordship.
What order is required? Mr.
Actually,
Lak-
Your Lordship, the petitioner was, the applicant was roasted out from the house, and that order was passed by the Honorable Trial Court that 20,000 should be given to her as an accommodation, as she was roasted out from the house. And subsequently, they have challenged that order. And in the meantime, another order was passed for 25,000 of as an interim maintenance order. That was also, they have challenged it. And in the trial court,
What is the order required today?
Yes, Your Lordship.
Notice has been issued by sole respondent. Have
Yes.
the respondents appeared?
Not today, Your Lordship.
Service report, just a minute. That is what we just need to know today.
Sir, it is completed, Your Lordship. Actually, on the
Dusty,
last.
have an idea. Upon sole respondent has been receiving the same instrument. seen the service report, seen the office note, madam, seen the office note dated 21/2026. The affidavit regarding the service of does the notice upon the sole respondent has been received. None appears today. List the matter again on 30th of March, allowing the respondent number, the sole respondent to appear.
Your lordship may proceed with ex parte because on the last occasion, if I am not wrong, Mr. Colsey has appeared. But
Huh?
Mr. Colsey, the advocate, learned advocate, Mr. Colsey has appeared, but he did not file his wakalatnama.
So we have given it only on the next Monday. Only on next Monday. Thereafter, we'll proceed.
Oblige.
One opportunity to
Yes, yes, yes. Oblige.
everybody is called for. What? Two. That judgment we'll have to deliberate too. We have seen corrections. We'll have the warrant, release warrant issued from here itself.
Oblige.
You'll have it after we get down in the corrections.
I'm being item 2.
This is the judgment I have collected.
Which one?
First is Gauhati High Court judgment. First one is Gauhati High Court judgment. Bail application 1207/25. Relevant portion is, my lord, page 3. Page 3 relevant portion. I just read out, madam.
I've seen. Heard. Mr. Mitra Rane counsel appearing for the petitioner, also heard Ms. Bora, learned APP appearing in the matter. This is a bill application under 438 arising out of PRC case number so and so, so and so. Stop. The charge sheet in the matter has been submitted on 30/12/2025 and on the petitioner having moved applications before the learned trial court, the bail applications were rejected only on the ground that the petitioner could not produce sufficient proof of a residence or a permanent resident in the state of Assam. The learned counsel for the petitioner has submitted that the petitioner is ready to face trial and the only ground for non-residence in the state of Assam need not be construed as a impediment to the grant of bail, which otherwise, since otherwise the petitioner is ready to face the trial. Full stop. The learned additional public prosecutor has submitted that there is sufficient incriminating material against the petitioner, who has also been charge sheeted. And since the petitioner hails from a different state, it may be difficult to procure their presence during the trial, and therefore she objects to the grant of bail. Full stop. I have considered the submissions made by the learned counsel for the contesting parties, and I have also produced a copy of the scanned copy of the TCR received. Full stop. It appears that the petitioner has been accused of impersonating government officials. Full stop. Since the charge sheet has been laid, further custodial detention of the petitioner may not be necessary in case they are willing to participate in the trial, full stop. This court is of the opinion that their presence before the trial court can be ensured by putting appropriate conditions while granting him bail, full stop. Accordingly, this court directs that since the petitioner has proclaimed himself to be a resident of a state beyond the jurisdiction of the trial court, the petitioner shall be released on bail on furnishing a bond of rupees 50,000 with two sureties of the like amount, at least one of them who shall be a government servant,
Yes.
serving either with the state or the central government, and at least one of whom shall have immovable properties in his name, full stop. To the satisfaction of the learned special judge. Where?
Golpara, my
Of the JMFC, Golpara,
CGM Golpara.
of the CGM Golpara, full stop. The, huh?
CGM Golpara.
Of the jurisdictional court at Golpara, of the jurisdictional court at Golpara, full stop. The jurisdictional court shall further be entitled to impose such conditions upon the petitioner to ensure his participation in the trial, it is further provided that the petitioner shall not leave it also appropriately modify special judge as jurisdictional magistrate. You will not leave the permission without prior, you will not leave the jurisdiction without prior permission. And
There is a flight trick.
you will give all your documents, whatever your passports and everything to the court. Then you will not change your address there without prior permission. And if you are within the state of, if you stay within the jurisdiction for the trial, then you will give the proper address. Be disposed of. Condition kita media anon doka change korle di dibo. Yes.
Coordinate bench, my lord.
This was regarding what?
36, my lord.
36,
Per
yes.
bench,
Only 36.
Yes, my lord. That time also wanted to see the coordinate bench with my lord. Same bench also, my lord, held that the mandatory requirement, my lord. That is bail application numbers. And it starts from paragraph 16, my lord. Okay. And if lordship permits,
16.
Yes, my lord, it starts from paragraph 16.
Yes.
Lordship also permits this other coordinate benches, my lord, order same aspect, my lord. That requirement of 36 is a mandatory one, my lord.
Yes, madam.
Lordship,
What do you say?
if Lordship, all other required mandatory provisions are complied with, section 47, 48, even arrest memo, inspection memo also. It is well informed that he has been arrested with specific sections of law, Lordship. What else is required, Lordship?
Would all the other things override 36? When
Otherwise,
36, when at the time of arrest, it is not signed by an independent witness.
you kindly see the inspection memo, otherwise.
That I have annexed, my lord.
Inspection memo is regarding what? The confiscation, the things which have been
Lordship.
recovered from
No,
him.
my lord. It is
Lordship, kindly go
injury,
through,
injury part, my lord.
Huh?
It is for the injury part.
Injury part.
Yes,
inspection memo is page 52.
I have annexed, my lord.
Page 52.
Yes. That is, my lord, whether there is any injury or not on the body of the person who has been detained or
But
arrested, my lord.
if he is prejudiced because of this procedural lacuna of the, on the part of.
No,
the
no,
prosecution.
inspection memo is something which happens after the arrest.
After the
Lordship,
arrest, for the
So we are on the arrest now.
Yes, my
Lordship.
lord.
At the time of arrest, that this is the time when he is arrested. How do we find that? This inspection memo, it doesn't say that the medical officer was present when the arrest took place.
Lordship.
That a man was arrested at 1 o'clock on 172025.
So and so.
Lordship.
It is only the arrest memo which will carry a signature saying that yes, at 1 o'clock I saw him being arrested.
Lordship.
Now, if the man is arrested at 4 o'clock, produced before the doctor at 5 o'clock, and he is shown to be arrested at 1 o'clock, produced before the magistrate next day on 6 o'clock,
No, sir.
entire thing goes.
Whether he has taken that ground.
He has said that 36 is not, it is not signed, so my arrest is not verified.
Before the trial court that he has been prejudiced.
Whether he is
That is he has
required
not
to
taken,
be,
Lordship.
whether he is required to take such
He's
grounds.
not taken precedence, Lordship.
When we refer to it, we are just giving a view of why 36 is held to be a violation of fundamental right.
Lordship.
What can go wrong?
Lordship, section 21, subsection 1 of one of the Constitution of India, it guarantees right to be informed about the grounds of arrest. That is
Said aforesaid observation of the Apex Code leaves no room for doubt that the aforesaid procedural requirement contained in section 36 has emanated from Article 21.
Lordship. So there is no such violation as regard to Article 21, subsection 1 of the
36, when
because
it is
grounds
not
of
signed.
arrest has already been informed, Lordship.
When 36 it is not signed, everything has a particular stage. 36, the moment you are arrested,
Lordship.
someone should say, yes, I saw him being arrested. Gun.
Otherwise,
2 hours before production before the magistrate,
Lordship.
you are required to give 47 and 48.
Lordship.
So, if a person is arrested at 1 o'clock, he is produced before the magistrate at 5 o'clock, you have to give 47 and 48 at 3 o'clock. But the violation which took place at 1 o'clock when no one saw him being arrested, what happens then? That is the issue.
And
At the
to
same
that
time, Lordship,
aspect,
kindly consider the gravity of the offense. It is recovered from the.
How many days?
265 days.
265 days, yes.
It is the discretion of the court.
But I'm a local person, my lord,
Court is not bound by the coordinates, bench chancellors.
But then we cannot also run totally against headlong into it, can I?
Lordship.
Therefore, we kept it for this time. Accused persons are, see, 19 years and 24 years.
Lordship.
with whatever stringent condition lordship would be.
That is what, Lordship?
Total weight, how much?
Lordship, 870.07 grams of heroin, Lordship.
Of heroin, oh.
Much more above commercial quantity. Lordship. That is what, Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner also heard the learned APP, the trial court record, scan copy of the trial court records received have been produced. This is an application under Section 483 of the BNSS 2023 for granting bail to the petitioner who is in custody since 1 July 2025 in connection with special NTPS case number 71 of 2025 pending in the Court of Special Judge Sri Bhumi, Assam. Full stop. The learned counsel for the petitioner has submitted that at the time of arrest, the arrest memo was not countersigned by any independent witness. And is there any other ground? 47, 48, anything?
No, my lord, 47, 48, I have not taken the ground.
Just complied with it.
36, the arrest memo was not signed by, was not attested by any independent witnesses. Full stop. Accordingly, he has submitted that the arrest of the petitioner being vitiated for violation of the mandatory provisions of Section 37 of the BNSS, the petitioner would be entitled to bail. Full stop. The learned APP appearing in the matter has submitted that although the arrest memo may not have contained the signatures of an independent witness, the inspection memo and other documents such as the notice under Section 47 and Section 48 of the BNSS 2023 having been supplied to the petitioner in due time, the petitioner would not be entitled to the privilege of bail only on the grounds of violation of the provisions of Section 36 of the BNSS. Full stop. The learned counsel for the petitioner has referred to different judgments, different orders passed in bail applications of this court, where on the ground of violations of the provisions of Section 36 of the BNSS, this court has held the arrested person to be entitled to the benefit of a bail during the trial period. Full stop. having gone through the orders passed by this court in the different bail orders and also having gone through the facts and circumstances of this case, including the scanned copy of the trial court record, this court does not find any reason to differ from the opinion expressed in BA number 3650 of 2025 disposed of on 21/2026. And BA number 324 of 2026 disposed of on 13/3/2026. Full stop. The learned APB had placed reliance on the order dated 6/8/2025 passed by this court in BA number 2289 of 2025. However, we find that in that particular case, the court did not find any infringement of violation of fundamental rights of the petitioner, since at the time of her arrest, witnesses were present. Full stop. In the present case, the case diary does not reveal the presence of witnesses at the time of arrest. Full stop. In such view of the matter, this court finds that the petitioner would be entitled to the privilege of bail, since on the violation of the mandatory provisions of section 36 of the BNSS, and in the absence of any record to show the presence of witnesses at the time of arrest, full stop. Accordingly, the petitioner is directed to be released on bail on furnishing a bond of. You are of the same locality?
Yes, my lord.
On
With
furnishing
some
a bond of
stringent
rupees.
observation,
Huh?
With some stringent conditions.
On furnishing a bond of rupees 25,000. What was recovered? Heroin.
Heroin, commercial.
30,000 with 2 sureties of the like amount, one of whom shall be a government servant, serving either with the central or the state government, and another shall be a person with landed property within the jurisdiction of the learned trial court. Full stop. The learned trial court shall also be entitled to put on such strict conditions upon the petitioner to ensure his participation in the trial. Anything else?
Lordship, it should be 50 at least, because it's a commercial quantity.
Make it 50.
My lord, a bail bond to the
Yes.
bail bond to the satisfaction of largest special judge Shibhumi and DPS.
We said so. We said learned trial court.
Here instruction.
We said learned trial court.
Deep level.
Apply instruction.
Yes. Anything on the status report, madam?
Lordship,
Service of
yes,
notice?
That is awaited, Lordship.
My lord,
When were you arrested?
my lord, I was arrested 9/12.
9/12. When did you
Lordship,
take steps?
Earlier, Lordship, he was granted bail, Lordship. Thereafter, he was again put into custody after filing objection by the informant, Lordships. Now he is 102 days, Lordships.
Where is that
Okay,
objection
Lordship,
or the orders passed in objection?
Page 37, Lordships. In extra 8.
Oh, you have been threatening them.
No, Lordship, actually, this is a false allegation, Lordship, and your kindly see the FIR, Lordships. What kind of FIR, Lordships?
Where is the FIR?
Yes, Lordship. Lordship, page 17, Ranikula, Lordships.
Page 19, na?
Page 17, Ranikula, Lordship. And page 11 is the translation Bharat. May I read the Ranikula, Lordship?
Just a minute, boy. I'll read it. I'm looking for priority. Dohman badal. Yeah, this is Ratipa Dostat, okay.
Yes, Lordship. Acharudha, my lord.
Now, who had filed the objection?
My lord, informant, Lordship.
Once there are objections of this level, what is the statement of the victim girl? Has it been recorded anywhere?
Actually, I have not gone through
Huh?
I have not gone through the scan.
Some objection.
Recorded.
If it is cancelled, we'll find it difficult to interfere.
No, Lordship, kindly see, I have filed my petition.
See,
also.
the father is not there. The father is a half-made person. The mother is not there. Someone else has come and put in an objection.
Lordship, kindly see why the FIR file, Lordships.
Why?
Yes, Lordships. So there was a, my lord, quarrel between these two families, Lordships. I have, my lord, mentioned.
Regarding what?
Regarding Lordships, for a goat, Lordship, the goat of the petitioner went to the kitchen of the, my lord, informant, Lordship. Thereafter, my lord, some quarrel happened. And this allegation raised, my lordship. And only punishment, my lord, kindly see what kind of punishment, lordship. Only touch lordships. And at 10 o'clock, lordships. And thereafter also again they filed the objection, lordships. I have filed my petition also, lordships. My wife filed my petition, lordships. So, my lord, custodial intention may not be required at this evidence stage, lordship. Already, my lord, victim examined, informant examined, lordships. If it assumed that he has committed that offense, lordships, he got the sufficient punishment, lordships. No, any condition may impose, lordships. And 102 days, lordships.
This is not a case where whether you will, that you will not.
Any condition.
Someone had to go and pray for a cancellation of bail. Not impressed.
Lordship, kindly see that may be my submission may be appreciated, lordship, because why they have filed a fair, lordship, and what kind of offense I have committed, lordships. Only my lord, task part, lordships, and
Oh, that is why you were granted the bail at the first instance, were you not? You were on bail.
I have not committed any offense, I have not committed, lordship.
You were on bail, is it not?
Lordship.
By the special code itself, is it not?
The prosecution failed to file the charge sheet, lordships. The prosecution failed the charge sheet in the my lord mandatory period, lordship, within the mandatory period, lordship. Thereafter I got the bail, lordships. And thereafter again they have come, lordship. I have not done that, lordships. So, my lord, any condition may impose, lordship. 102 days, he got the sufficient punishment, lordships. So, my lord, at least.
Yes, madam, what do you say?
Lordship, actually today I'm totally handicapped. I have not, first of all, I have not gone through the.
No, it's okay. The evidence of the girl is there. Not only the girl, there are 3-4 more witnesses.
Lordship.
And one witness has turned hostile.
Lordship.
One insignificant witness has turned hostile. We are not on them. He was granted bail. There is an allegation he tried to go after them with a scooter and he was spitting on the road whenever he saw them. Therefore, the bail has been cancelled. 102 days. After that, how many days?
102 days, lordship.
From December, he is now in jail because of spitting. Can I allow the bail? Huh?
My objection may be recorded, but informant is not present.
Informant is not there. What to do?
Lordship, can you see the?
Lordship, at least today, Lordship may appoint a.
We'll appoint an amicus.
3 days already gone, Lordship.
That cannot be hard.
3 days of what?
My lord, for service of report.
Therefore we are appointing the amicus. Someone has to speak for the informant of the victim. Here it is not about the evidence part. Here the part is about you threatening them.
That is not done by my lordship. Yes, Lordship. Allegation is that, Lordship.
That is the allegation. Someone has to be heard on that, is it not?
That is true, Lordship. That is. Therefore,
So since the service report is awaited, no, the service report on the respondent number 2 is awaited, full stop. The learned counsel for the petitioner has submitted that although earlier the petitioner was allowed to remain on bail, comma,
Go on, Bill.
on an to go on bail, comma, the there was a petition moved in the trial court
Lordship.
for cancellation of the bail on the allegation that the petitioner had threatened the witnesses and that he used to try to hit them with his bike or scooty as well. It was also stated that he used to spit at them whenever he meets them on the road, full stop. It is on such allegations that by the order dated 9/12/2025, the bail granted to the petitioner had been cancelled. Full stop. The learned counsel for the petitioner submitted that no such incident had been that the petitioner was not involved in any such incident, and he was regularly facing the trial.
Lordship.
Full stop. The learned counsel for the petitioner has also submitted that even in the event that it is assumed that he had even in any event, comma, the petitioner has been languishing in custody after the cancellation of the bail for 105 days.
2 days.
102 days till today, and in any case he has learned his lessons and he will not repeat any, he will not allow any such incident again to happen.
Okay.
Full stop. And it is noticed that there is none to represent the informant oblique victim. In such circumstances, list the matter again on 27th of March, or should we keep it on the 30th of March?
25, 27, Lordship.
30. Let it be 30. On 30th of March.
102 days, Lordship.
Huh?
27, Lordship, kindly, Lordship. In this week, Lordship. During this week.
On the 27th of
Lordship.
March, the court appoints Miss Mr. D. Gogoi, learned counsel, as the amicus in the matter to assist this court. Full stop. The learned APP shall have also have the service report on the respondent number 2 to be placed before this court on the next date of listing. Full stop. List again on 27th of.
Lordship, Mr. D. Gogoi's name may be reflected in the cause list.
The name of Mr. D. Gogoi as amicus be reflected in the cause list. Petitioner to serve a copy upon the Mr. D. Gogoi during the course of the day. Today itself do it. We'll try. Yes, madam.
May I speak, Your Lordship?
Hmm.
Lordship, I beg to seek for adjournment for this matter, Your Lordship, since the contended counsel is having some difficulty as of today, Your Lordship.
A request has been made on behalf of the learned counsel for the petitioner for an accommodation today. Prayer not being objected to is allowed. List the matter again on
On 2nd of April.
2nd of April 2026.
46.
Yes.
Lordship, I have taken steps 3 times, my lord. First, my lord, on 9/10/2025, my lord, and service was completed at that time, my lord, but in the AD card's signature was not there. So Honorable Court directed to take fresh steps, my lord, and again I have taken steps on 26/11/2025, my lord, and service was not completed. Again I have taken steps on 19/2/2026, my lord.
Hmm.
And today is for service report.
What is this, what is the case, the PRC? What is the PRC regarding?
Bishop, question for the charge sheet, my lord.
Oh, what is the, huh?
Risk question. for the charge
What
sheet,
is,
my lord.
what is the allegation in the charge sheet? What have you done?
Allegation, my lord, in FIR, my lord, I was not named in the FIR, my lord, but charge sheet in the charge sheet, my name is
Have you seen someone going round and round in the football
Bishop,
field without
no-
touching the ball?
No specific allegation against me, my lord.
Okay, then what is the specific allegation against the other co-accused?
There is a forgery, my lord, for granting loan, my lord.
Hmm. So who is the respondent number 2?
Respondent number 2 is the informant, my lord.
Oof. Yes, tell us one thing. This Nitya Chandra Das was a then zonal general manager.
Yes, my lord.
Will he receive any copies of this?
Whether, my lord, I have to check the order sheet, my lord.
Hmm.
Because they have taken steps on 19-2, my lord.
19?
19-2.
Huh.
My lord.
Now, if this man is not there, this Nitya Das, if he has gone away from that,
Record to the main record to.
it will again. This one?
This one, my lord.
But AD not received back.
Then, my lord, we have to wait, my lord. Otherwise, my lord.
Is the man still serving there?
No, my lord,
He has left. He has left. Then
Retired.
all your ADs will be like that only. He has left.
he retired,
But
my
the
lord.
report has to come, my lord. Then only it can be proceeded.
Huh? File an affidavit saying that he is no longer in that office.
Dusty may be allowed, my lord.
Huh?
Dusty
Dusty on whom, if you are saying that the man is not there, you will be only wasting time. Yes. Heard the learned counsel for the petitioner. The service report on the respondent number 2 is awaited. Learned counsel for the petitioner has submitted that although several times steps by registered AD and speed post has been taken, comma, the service could not be completed. Full stop. He has also submitted that the respondent number 2, who was the then zonal manager, may have left his office. Full stop. He has, however, prayed that he may be allowed to take dusty steps on the respondent number 2. Full stop. Awaiting service report by awaiting the service report on the steps taken by the petitioner through speed post, comma. The petitioner is also allowed to take steps by dusty upon the respondent number 2 through the registry of this court. Full stop. Petitioner to take steps within the next 1 week. Affidavit regarding this service of notice by dusty be filed within a period of 1 week after service of notice. List the matter again after the affidavit of service by dusty is filed. We are not fixing any date. You go, you serve it, you bring it back. Yes.
Most of that.
Babu. Aru.
My lord, let him take steps in the office, my lord. Office of the respondent number 2, my lord. Because they might, my lord, then appoint somebody else.
No,
my
then
lord.
someone will go from here with that name. He will file an affidavit saying that since the man is not there anymore, why should we assist him? He is not taking his own steps. He is not filing an affidavit saying that the man has gone, let it be served on the zonal manager. Is it not? He is not doing it for him. Are we here to guide him? He wants to take the steps on a person who he says is not there. What can we do?
My lord, yes, my lord, my humble submission is that, my lord.
Is there a stay in the matter? No.
He
There
has-
is no stay. He is not taking the steps properly. What can we do? He is up for dusty. We have allowed it.
My lord, my humble submission is that, my lord, this person, my lord, he filed this as my lord, on behalf of the bank, my lord.
See, sir, you are stating on the law. We are stating on the law. We want the case to proceed and come to its natural.
My lord, my lord. Yes.
He does not want it. He has not said that I will take it on the office. He wants the case pending. Steps after steps. So be it. 1 or 2 cases, we have to allow that also.
My lord.
All cases, if you take out for disposal, it will be difficult. Yes, if that man is not there, why don't you take steps on the office?
He's the informant, my lord.
So, now the informant is gone. Without that informant, what will happen? Who will defend it?
Then, my lord, I may be allowed to.
Who will defend it? The office.
Then, my lord, I may.
You don't have a stay with you. Is there a stay? No. You are facing the music there. You are not asking, you are not making the proper remedy here. What to do? File and take the steps. Why does he come and tell us that yes, that man is no longer there? I want to, what do you say? Strike out the name and have the office included. We'll have a cost title file. You can then go and serve him and we can proceed.
Yes, my lord.
Allow dismiss is another part. But at least proceed. Yes.
Item 48 and 49.
Yes, sir. To the file কোন আছে?
Typically, pass the judgment in 49.
Huh.
48 is for completing the process of DPC. So in 49, my lord, because in 48 they have said that that gradation list has been tinkered. So therefore, judgment may be passed in 49.
Heard Mr. B.D. Das Learned to 49 at Lobo. Heard Mr. B.D. Das Learned counsel paying for the petitioner. I got it. To scroll the detox, huh? I'm having a consistent irritation on the throat for the last around 1 month. Issued by the Joint Director of Health Services, Assam. Full stop. During the course of his service, the petitioner was promoted to the post of an upper division assistant in the office of the Joint Director of Health Services, Dhemaji, by an order dated 34/2008. Full stop. The petitioner came to be transferred in the capacity of an UDA, which he was still holding, to the office of the Joint Director of Health Services, Lakhimpur, in place of another upper division assistant, who was also transferred. Full stop. By an order dated 28/9/2018, the petitioner's earlier transfer order was modified, posting him against the then existing vacant post of UDA in the office of the Joint Director of Health Services, Dibrugarh. When were you
Post of it was filed vacant on 1/12/24.
No.
Post of head assistant.
No, you were saying that you were working as a senior assistant. At page 30, you say that you are working as a senior assistant. When did they become UDA was designated as senior assistant, is this? In the meantime, the post of the upper division assistant had been redesignated as a senior assistant. Full stop. When the post of the head assistant of the office of the Joint Director of Health Services, Dibrugarh, was about to fall vacant on 30/11/2024, the petitioner submitted a representation / application for promotion to the said post. Full stop. On the said application, the Joint Director of Health Services, Dibrugarh, communicated with the Director of Health Services, Assam, stating that the post of head assistant would fall vacant on the 1st of December 2024 and there would be no objection from the office in case the petitioner is promoted to the post of head assistant in the office of the Joint Director of Health Services, Dibrugarh, full stop. By a communication dated 19/11/2024, the Joint Director of Health Services, Dibrugarh, forwarded a gradation list of the upper division assistant within bracket, freshly nomenclatured as senior assistants, to the Director of Health Services, Assam, where the petitioner was shown to be senior to the respondent number
4.
Respondent number 4.
Serial number 1.
The petitioner was shown to be the senior most person with the date of promotion to the post of UDA being 1/4/2008, while the respondent number 4 was shown at serial number 2 of the gradation list with date of promotion to the post of UDA to be 2/7/2011. Full stop. That by another order, a communication dated 18/5/2024, the Joint Director of Health Services forwarded another gradation list to the Director of Health Services, Assam, where a particular Mr. Ashok Kumar Fukan had been shown to be senior to the petitioner with his date of promotion to the post of UDA being 5/3/2007. The petitioner was kept at serial number 2 with the date of promotion to the post of UDA at 1/4/2008, and the respondent number 4 was kept at the serial number 3 of the aforesaid gradation list with his date of promotion to the post of UDA being shown as 2/7/2011. It appears that in the meantime, Shri Ashok Kumar Fukan, who was shown to be senior to the petitioner by the gradation list of 18/5/2024, had been given the promotion to the post of head assistant, and he was supposed to retire on 30/11/2024. The Joint Director of the respondent number 4 thereafter made a representation to the Director of Health Services, Assam, praying that considering the seniority given in the aforesaid communication itself, aforesaid communication dated 25/11/2024 itself, the respondent number 4 be considered for the post for promotion to the post of head assistant, full stop. In the aforesaid representation, the respondent number 4 had shown his date of promotion as to the post of UD as 2/7/2011, and the date of promotion of the petitioner herein as 1/4/2008, full stop. The date of joining in the present district as an UD assistant for the respondent number 4 was shown as 2/7/2011, while the said date of joining in the district as UD assistant for the petitioner was shown as 4/10/2018, with the remark that the petitioner had been transferred to the said district, full stop. The Office of the Joint Director of Health Services thereafter. What date is this? This annexure 12, page 41.
4/11/19.
Why should we go back to 4/11/2019 at this point of time? No.
It's not necessary. They have cancelled, impugn order is 27/1/25. Page 45.
Which is 22/1/2025. Where is it? 22/1/2025.
27. Page 45. 27/1/25. Page 45.
Who has signed this?
Next page.
References subjects cited by
Joint director.
that the office has
It is a typed copy.
was submitted along with guidelines from 19/11/2024. Where is 19/11/2024?
1911 is page 32.
Huh?
Page 32. 1911.
Hmm. 1911 to recording so and so, so and so, so and so. Since there is no any objection, so by this 22/11/2025, this 19/11/2024 was upheld. Do we understand it like that? With reference to the subject cited above, I have the honor to inform you that this office has something dated 19/11/2024 was submitted along with gradation list of senior assistant. Recording from of our official record of Sri Biman Borua is a senior most of upper division assistant Assam under establishment. Sir, there is no any objection if is.
That is at page 43.
Huh?
Page 43.
Page 43 is all dot 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 mostly.
No, this is only the typed copy.
Huh?
The next page, page 40.
Page 44 in this is what we are trying to read. Page 44 is what we are trying to read. If you
Page
have a look.
44 is I mean, it's not legible.
Is it legible in the other copy section? That on page 44.
He said petitioner is the senior most, he has no objection.
What did we write the last sentence, madam? By a communication, by a communication dated 22/1/2025, addressed by the Office of the Joint Director of Health Services, Dibrugarh, to the Director of Health Services, Assam, it was communicated that the gradation list sent along with the communication dated 19/11/2024, showing the petitioner to be the senior most upper division assistant was correct, and that there was no objection if the petitioner was promoted to the next higher post of head assistant. Full stop. Where is that fresh gradation list at which is spoken of at page 45?
Page 45, not even get.
Huh?
Page 30. Page 45 and 16.
Page 60.
60. Where the petitioner has been shown as serial number 3.
Yes, yes. What is in between?
How many gradation lists there? It's 45. By this publication earlier gradation list was kept.
Which earlier gradation list dated?
The 19/11/24 and 22/1/24.
Okay. The Office of the Joint Director of Health Services thereafter issued another communication dated 27/1/2025 to the Director of Health Services, Assam, thereby cancelling the gradation list dated 19/11/2024 and the letter dated 22/1/2025 and submitted a fresh gradation list of UD assistant based on a previous gradation list of 2019. Full stop. The said gradation list dated 27/1/2025 had placed the respondent number 4 over the present petitioner by showing the date of joining in the present present place of posting at Dibrugarh to be 27/2011 for the respondent number 4, comma 28/9/2016 for for another employee, and as 4/10/2018 for the petitioner. But this Nivedita Kolita is not a party here. Huh? She is a party. The other person who has been shown to be senior to the petitioner on by the gradation list of 27/1/2025 is also a party to this writ petition as respondent number 5. You are representing respondent number 5 also? Stop. She is represented through the counsel who is also representing the respondent number 4. Stop. Next paragraph. Being aggrieved by the aforesaid gradation list dated 27/1/2025. What is your prayer here? 27/1/2025. Placing the respondent number 4 and 5 above the petitioner, and also praying for a direction to maintain the seniority of the petitioner in the gradation list dated 19/11/2024, comma, this present writ petition has been filed. Full stop. It will be relevant to mention here that the petitioner has also filed WPC number 1350 of 2025, by which the petitioner had prayed for the finalization of the DPC, which had earlier considered him for promotion to the post of head assistant and which had not been brought to its logical conclusion by the respondent authorities. Full stop. During the pendency of the aforesaid writ petition, comma, the petitioner had come to know about the introduction of the new gradation list on 27/1/2025, and therefore this writ petition had been preferred, challenging the gradation list, comma, without which the prayers in WPC number 1350 of 2025 could not have been pursued by the petitioner. Full stop. Have you filed your affidavit in the second petition? You do not intend to. Ha. An affidavit in opposition has been filed by the Director of Health Services, Hengrabari, Director of Health Services, Assam. How many respondents are there? 5. Who is the respondent number 3? This this affidavit would cover the stand of the respondents number 1, 2, and 3. Full stop. The learned counsel appearing for the respondent number 4 and 5 have submitted that he would rely upon the stand taken by the state respondents in the matter and would not be filing any affidavit, other affidavit for the respondent number 4 and 5. Full stop. A perusal of the affidavit in opposition filed by the respondent number 4 and 5 reveals that that day we got some impression that they are not pursuing the 27/1/2025. Huh?
The other writ petition, the affidavit,
Uh-huh.
a note I have stated, my lord, second page, paragraph 3, it was clearly admitted that.
The WPC 1350.
Yes, paragraph 3.
Paragraph
3.
3. The respondent authorities have also filed their affidavit in WPC number 1350/2025. Comma, which is a more elaborate affidavit describing the stand of the respondent authorities, full stop. In the said affidavit filed in WPC 1350 by the Director of Health Services, comma, where is that part? Where did they say that
Paragraph 3.
the 27(1) we are not accepting? Somewhere I remember reading that.
Second affidavit. Their affidavit is there.
They have not
The
said so.
second.
No, I had taken a wrong impression, possibly. The stand of the respondents of the stand of the respondent Director of Health Services is, to the extent that the Joint Director of Health Services had been submitting different gradation lists at different point of time, which had created a confusion regarding the seniority of the incumbents, full stop. It is also the stand of the Director of Health Services that further steps for considering the petitioner for promotion to the post of head assistant could not be taken, since the WPC number 1350 of 2025 was sub judice before this court. Full stop. It has been stated in the affidavit that action regarding the promotion of the petitioner hearing would be taken immediately after directions or judgments of the court in due course, full stop. The stand of the respondent authorities as depicted in the affidavit in opposition does not.
They have also filed affidavit in this case, 527.
But here also they have not said anything. No?
Anything. They said we have not informed the parties.
That is okay. But if we now ask them to inform you, then take your opinion, then do it, it will go. The affidavits filed by the Director of Health Services in the matter does not reveal as to why or how the gradation lists of the upper division assistants, within bracket likhibo, now designated as senior assistants, had been changed by the Joint Director of Health Services, Dibrugarh, from time to time. It is the particular stand in the affidavit in opposition of the respondent number 2, filed in WPC number 5275 of 2025, that the petitioners or the private respondents or any other incumbents had not been informed about the rapid changes in the gradation list by the respondent authorities, since it was not considered necessary to inform the petitioner regarding the preparation and submission of the gradation list, full stop. This court has heard the learned counsel appearing for the contesting parties and has also considered the different annexures appended to the writ petitions and the affidavit in opposition, full stop. There is no quarrel at the bar that the petitioner had been appointed in the year 1996. No, that the services of the petitioner had been regularized in the post of lower division assistant with effect from 1/4/1995 by the order dated 27/3/1996. It is also an admitted position that the petitioner had been given his promotion to the post of upper division assistant at the Gogamukh LCU by the order dated 30/4/2008. It is not the case of the respondent number 4 and the respondent number 5, or the state respondents that the respondent number 4 and 5 had been promoted to the post of upper division assistant prior to the petitioner being afforded his promotions to the said post, full stop. The petitioner had been transferred from, where were you then? From Dhemaji to Lakhimpur in the interest of public service by the order dated 24/8/2018, which order came to be modified by the order dated 28/9/2018 only to the extent that the place of posting of the petitioner was changed to the office of the Joint Director of Health Services, Dibrugarh, in place of the office of the Joint Director of Health Services, Lakhimpur, full stop. Thus, this court notices that the transfer of the petitioner was in public interest, full stop. It is a settled position in law that the seniority of an incumbent to a particular post cannot suffer to his detriment if he stands transferred from a particular district to another in public interest, full stop. Therefore, this court is of the considered opinion that the petitioner would retain his seniority in accordance with the date of his promotion to the post of UDA, even though he was transferred to a different district in the year 2018. Full stop. From the documents appended to the writ petition and to the affidavit in opposition, it appears that the Joint Director of Health Services, in the year 2025 had considered the date of joining in at Dibrugarh by the different incumbents to create a fresh gradation list of the UD assistant, thereby placing the respondent number 4 and the respondent number 5 ahead and above the petitioner who had joined the office at Dibrugarh on 4/10/2018 but had been promoted to the post of UDA at least 5 years ahead of the respondent number 4, at least 3 years ahead of the respondent number 4 and 5 years ahead of the respondent number 5, full stop. This court cannot accept the gradation list dated 27/1/2025 since it tampers with the seniority of the petitioner only on the ground of the date of joining at the present place of posting without any reference to the date of promotion of each of the incumbents to the post of UDA and without reference to the fact that the petitioner had been transferred, who had joined at Dibrugarh on transfer in public interest, full stop. Accordingly, this court is of the considered opinion that the gradation list dated 27/1/2025 requires an interference and is accordingly interfered with, full stop. The gradation list dated 27/1/2025 accordingly stands quashed and set aside, full stop. Next paragraph. It is not disputed by the respondent authorities that the case of the petitioner had been taken up for consideration for promotion to the post of head assistant in the office of the Joint Director, Joint Director of Health Services, Dibrugarh, on his own turn on the basis of his seniority and as per the affidavit in opposition filed, the respondents would bring the aforesaid process initiated to its logical conclusion on the disposal of the writ petitions which are pending before this court, full stop. Accordingly, the respondent authorities are directed to carry out the process initiated. Where is that DPC process? Anywhere?
It's 10.
If they
There are
get-
6 I have stated, madam.
We need their
13/12/24 it was initiated and did not complete.
which was initiated by, which was initiated on 13/4,
13/12,
3/12.
13/12.
3/12. Please come to page 35 of the first read petition, the affidavit filed.
It's all right.
It is 3/12/2024.
That is the-
Now then they will come back saying that there is no process on 30/12 or 3/12. Therefore, we need to be a bit sure. Page 8, no, page 3 of the affidavit in opposition, running page 35. It says 3/12, yes? Accordingly, the respondents are directed to proceed with the departmental promotional committee proceedings, which was where the case of the petitioner was placed for consideration on 3/12/2024 and 3024 and consider the case of the petitioner for promotion to the post of head assistant, comma, taking his date of taking his counting his seniority on and from, what was the date of promotion?
2008.
4/10 1/4/2008, taking his date of promotion to the post of UD assistant to be 1/4/2008, full stop. The affidavit in opposition of the respondent authorities have stated that the committee could not, on the earlier occasion, complete the consideration since some documents were found lacking and a request had been initiated to place the same before the next DPC meeting along with proper documents, full stop. The respondents have not divulged what proper documents were missing at that particular, before the particular DPC, full stop. Accordingly, the Joint Director of Health Services and the Director of Health Services shall ensure that all relevant supporting documents required for consideration by the DPC shall be placed before the relevant DPC so that a complete consideration can be given to the petitioner for promotion to the post of head assistant, full stop. The petitioner, the respondents shall ensure that the consideration by the departmental promotional committee and a finalization to the prospect of promotion of the petitioner to the post of head assistant shall be carried out within a period of 4 months from the date of receipt of a certified copy of this order. Full stop. Yes.
2 months.
No, the thing is, April would be gone in elections.
Optional ballot
The
beneficial
April month will go in elections.
section. Then may
Then by May or June, they will start the process.
not take so much of time.
We have 3 months from the date of receipt of a certified copy of this order. Full stop. Since the petitioner's case was first due to be considered in the year 2002, admittedly in the year 2024 by the respondents, comma, in case the petitioner is found fit for promotion in all other aspects, comma, by counting his date of seniority from 1/4/2008, comma, he shall also be granted the notional benefits that would have accrued to him had the promotions been granted by the DPC, which had initially considered him on 3/12/2024. Stop. Anything more?
No, Lordship. Can it be 4 months, Lordship? 3 months would not be.
Move an application, we need 1 month more. One IA and we grant it. Is it not? That is why so many contempt cases are pending.
Lordship.
All you could have done is asked for 1 more month, 2 more months.
So we don't want.
This court will not hold itself back from granting. Acha, in view of the orders passed in WPC number 5 5275 of 2025, comma, no orders are required to be called for in WPC number 1350 of 2025. Full stop. The IAs have they been disposed of? So soon I can dispose.
I was implemented. Not disposed.
I dispose of. Anything? I'll go ahead.